although you don't
Ah,
require an introduction, but still, as a matter of tradition and practice, I just give you the introduction of Mr. Lokdeep. He's also a qualified chartered accountant and a renowned lawyer in restructuring, and is in the law practice since 1983. As far as I know him from National Textile Corporation, one of the biggest restructuring account in India. Since last 20 years. And he is a specialist in corporate and financial restructuring, insolvency laws, merger and acquisition, banking law, and real estate. He is a managing partner of Deer and Deer Associate, which is rated as one of the top insolvency firm in India. He has a presence not only in India but internationally also. He is the co-chairman of many associations, including SOCOM, and he is in a lot of committees of Government of India, of IBBI, ICSI, and many things, many similar committees also. We are really blessed with your, your deliberation, sir. अपने लिए 2 4 5 मिनट last में spare रखना. We have some volley of questions for you also. Please start your deliberation, Alok sir.
thank you, Manojji. I think it is very kind of you to say what you did. We are all humble practitioners and we are all colleagues in that sense, and we learn from each other every day. It's just that this is an opportunity. And I must tell you, every time one speaks, there is an opportunity to try to reflect upon things, and you end up gaining more from having come forward than anybody else who's listening. But let me start by thanking AIIPA and Manojji, the president, to invite me for speaking on the expectations of the IPs from the COC. So Mr. Sunil Chugh has just spoken on the expectations of the COC from the IP. Both are very interesting topics, as the relationship between the COC and the IP is in the center stage of the entire IBC, particularly the CI. That's the crucial linchpin for the entire process. When I read the topics for the day, I just reflected a bit as to what is the expectation from each other in a relationship. I mean, on a larger scale rather than just IP and COC. Both COC and RP are two crucial pillars of the resolution process to achieve the effective resolution of a corporate person in a time-bound manner. They are bound together in an exceedingly complex but symbiotic relationship by the provisions of IBC, rules and regulations
Super sir.
framed thereunder, and if I may
For
say now, the code of conduct which is there already for the RP and is likely to be there for the COC
ये
as
सारा कर दे. एक और, रुक रुक थोड़ा देर.
well. So they have to act in tandem with each other to achieve the desired objective. One cannot perform its role without the support of the other.
ये भी कर दे.
The code envisages the COC to be the primary decision maker and the supreme decision making body, and RP as the master of ceremonies to conduct the process and create an environment within which the COC can take effective and pragmatic decisions to resolve the corporate debtor for the benefit of the stakeholders and contribute to the economy of the country. So that is the mutual role between these two. So for this Jugalbandi to succeed, the RP has to act in the best interest of the creditors as a whole, in good faith, fairly, honorably, independently, impartially, within the four corners of law. And equally, the COC has to support the entire process and the RP by taking timely and fair decisions in the larger interest of value maximization and balancing the interest of all the stakeholders. The expectations of the RP from the COC and vice versa arise out of mutual respect, rights, duties, responsibilities, and obligations towards each other, and the powers given to them respectively under the provisions of the IBC to achieve the common objectives under the Act. It's like both of them are running a three-legged race. They are tied together from hand to foot. They have to synchronize and calibrate each step in the larger interest of achieving the objectives of the IBC. One wrong step by either party can land the whole process in trouble. The RP is also like a sutradhar in this process. He is the director and the master of ceremonies, but the ultimate beneficiary, the decision maker, are the financial creditors who compromise the COC and the other stakeholders. On a lighter side, when I was looking at the relationship and expectations from each other, I just thought in my mind that this relationship can also be compared to a marriage. The husband is the RP. He has to do all the work. All the hard work has to be done by him. He has to run the process. He has to do everything. He has to keep the process within the four corners of law, convene meetings. So there's a lot of work that he has to do. But whatever he ultimately generates, when the resolution happens, everything goes to the wife, to the COC and the financial creditors. He can give his suggestions, but ultimately, as we all know, he has to do what his wife tells him. So in that way, the RP status is this, that he is responsible for doing and running the entire process, but he is under the ultimate command of the COC. Also, again, another analogy of the relationship I'll give is the relationship is like between a Pandit and his Jajman. The Pandit is the RP. He is appointed by the Jajman, the COC. He is technically qualified. He knows all the mantras. As in the case of RP, he has to know all the laws. And conducts the entire ceremony, which is the other. But what are the blessings of God ultimately go to the Jajman, which is the COC. They are the ones who are the principal stakeholders who benefit from this. So the IP does not benefit from the process in any way, except for the purpose of getting his fee for doing the entire exercise. So the entire process starts with the filing of the petition under section 7, 9 or 10. RP is recommended by the applicant in the respective case, and on the admission of the petition, the adjudicating authority appoints. The RP collates all the claims, forms the comprising of the financial creditors, except of course the related parties. He has to convene a COC meeting within 7 days of constituting the COC. And from that date, the jugalbandi between the RP and the COC starts. The RP, and just to see what are the respective powers, the RP has been given the power to manage the affairs of the CD, and the management of the CD vests with him in terms of section 17 and also 23(2) between IRP and RP. Section 18 lays down the duties of the RP. What are the duties that he has to perform? The COC, on the other hand, is constituted under section 21 and has the right to take all decisions in the IRP process with voting rights of majority of 51%, except for very crucial right, and that is the replacement of the RP in terms of section 22(2) and 27, approval of resolution plan under section 34, and all actions to be taken by RP under section 28(1) with 66% majority. Just give me a second. Beta suno. The right of the COC to replace the RP is a very crucial right and defines it as an ultimately superior authority in the relationship between the two of them. This right has led to certain pressures on the RP. There are cases which we have come across where the RP has been, I'm not taking, it's not a question of the legal issues in this matter today. The issues where the RP has been pressurized to pay the dues of even the financial creditors and their lawyers. There are cases where the RP has been pressurized to pay the amounts to the financial creditors from out of the funds of the corporate debtor. All these have been brought into the ambit because there is that special right that the COC has of replacing the RP. Now, what we have to understand as we go along in the CIRP and the development of this law in the country, that when the code of conduct of the COC kicks in, we have to see and ensure that the COC exercises this right in a very reasonable and fair manner. As things stand today, as we are all aware, even the Supreme Court has held that there is no requirement for the COC to give any reason whatsoever for replacement of the RP. In case there is no such obligation on the COC to give any reason for replacing the RP, the position of the RP becomes vulnerable, and he is always obligated to the COC for his very existence, which may ultimately lead to certain practices which may not be desirable and in the long-term interest of the CIRP process. And insofar as the code of conduct which is being promulgated with respect to the COC, there are certain issues in that code of conduct which are very important and we need to look at them. One of them is that the COC is required to cooperate with the RP. Very, very crucial, because without the mutual cooperation between each other, this will not work. Then, not to influence the decision of the committee or the RP. So, keeping that strong position that the COC has with respect as against that of an RP, the influencing of the decision by the COC of the RP should not happen, because this will disturb the balance of the IBC altogether. Also, the COC has the responsibility, and therefore RP has an expectation that will facilitate the appointment of professionals within specified timelines. Within specified timelines. They have to cooperate with the RP for giving various approvals which are required to be given from time to time, including extension of timelines, because without the approval of the COC, even the RP is not entitled to proceed to seek extension of timelines for conduct of the COC. In provision of interim finance is also a very crucial expectation that the RP has. Many times we have seen that the COCs don't have cash flow generation. They don't have money to pay the RP. They don't have funds for the purpose of security of the corporate debtor. They don't have funds for the payment of professionals. They don't have funds for even the newspaper advertisements which are required to be given. So the expectation of the RP and the responsibility of the COC as per the code of conduct would be that they have to make sure that funds are available. Either they should be brought in as interim funds and they should give approvals. We have seen in many cases that the COCs are differing. Some interim finance NBFCs who are willing to give money are asking for their pound of flesh. They are asking for high interest rates, undoubtedly. But if there is no money to conduct the process, what will the RP do? The COC has to act. Either the COC should see as financial creditors, they should provide the money, or they should allow the RP to get the money. Then they have to also ensure that they are taking the measures to see that the cost of the CIRP are reasonable. In many cases, it has been seen that highly exaggerated costs get booked for the CIRP, and that creates a difficulty at the stage when the resolution plan is to be approved and distribution has to be done. Then the expectations of the RP are that all the COC members will attend the meetings. We are seeing sometimes even quorum is not there. The COC members are not even coming for the meeting. In one of the cases, the NCLT owned logistics, if I'm not mistaken, has put a fine of 1 lakh rupees on the COC member for not attending a single meeting during the entire CIRP process. Then they have to ensure that tactics of delay tactics are not there in decision making with respect to resolution plans. So we have seen the resolution plan is to be placed before the COC. They take such a long time in discussing the plan because they are not authorized. The people who are attending, the COC members who are attending the meetings are not authorized by their respective banks for the purpose of decision making. So it is a legitimate expectation of the resolution professional that they will appoint such persons who are entitled to take decisions. I must say, I'm so sorry, Manojji. I must say I could have gone on and explained this further, but it's extremely difficult for me because I have to attend a crucial personal function and I must leave now to be there in time. It's just that I wanted to be here with you all and I did not want to last minute say that I'm unable to come today. So you must excuse me today, sir.
Yeah, thank you
Mr.
very
Chugh,
much.
I must apologize to you again for having interrupted you for 15-20 minutes. And it's not fair of me, but unfortunately the situation so demanded.
No issue. We are with you. You can go ahead and attend.